I just wanted to say, first off, I'm really pleased to be working with the Canadian Centre for Men and Families. And I like the fact that they are focused on helping fathers go through a very difficult time in their lives, and the focus being on not on their rights per se, but on getting fathers the assistance that is sometimes overlooked in the systems, because men do have sometimes unique ways of dealing with breakup of intimate relationships. So I'm very pleased to be working with CCMF. And I just wanted to start off with a kind of a comment about the title of this webinar, because it's a little curious and saying parenting when your ex won't let you see the kids. And and it's like, well, okay, well, how can we do any parenting when the ex won't let me see my kids? So what we're trying to do here is really address the issue of how to get into parenting, or how to restore your parenting relationship, dealing with a situation where your ex won't let you see your kids. So I wanted to give you a bit of background about myself. The first family law trial I ever did about 25 years ago now, on a custody and parenting matter. It was a 5-day trial, and my client did not look like a very pretty client at the beginning. In fact, after day one, the judge came to me and said, actually called the lawyers into his office and said in front of the other lawyers, "Mr. Fair, your client is a ruffian. What are we doing here? Why are we wasting 5 days of trial on this?" And I said, "Your Honor, with all due respect, the evidence still has to come in before you." And we went from a situation where the mom was saying strictly no contact, and the child had a supervised had a sorry, the child had his own lawyer, and that lawyer was saying strictly supervised access. And at the end of it, we got regular uh, every other weekend unsupervised access. And my client was probably quite seriously a ruffian. He had assault convictions, had spent time in jail, uh, domestic violence, and that sort of thing. But it occurred to me then, and it's always struck with me, that situations can seem really, really dire, but they are not impossible to deal with. And I think as I reflected on why that case was successful, I realized that there was some things about it that really, really helped. And part of it was my approach as a lawyer, part of it was what the client was doing, and part of it was just the advantage of having some very favorable witnesses. I do want to say that so success is possible. I just want to say that success is possible, but it may not be, and it certainly is not guaranteed. And but even if it's not guaranteed, even if you aren't successful, or success seems a long way away, there are always things that you can do, even when it's really, really dire. Uh, I want to give you a reminder as well that what I'm saying here today is not legal advice. I don't know the specifics of your situation at all. And every case, particularly in this area of family law, every case really is different. And what might be an appropriate strategy for one person in their circumstances may very well not work out to be a good situation in somebody else's circumstances. And my apologies for my excited dog. I'm doing this webinar from home today, rather than from my office, so hopefully the dog won't interfere too much. In any event, okay. Um, with that aside, as I said, parenting, when one parent is cut off from the children's lives, this is probably the toughest area of family law. It's very complicated, and um, the and that's the reason why we really can't say, look, this is how you fix your problem without really knowing a lot about it. There's a lot of complexities. The courts are just trying to do right by children, and parents are typically somewhat less than perfect. None of us are perfect, and certainly children don't come with instruction manuals, and parents come not only with problems with how they parent their children, but also they have their own sets of baggage, and that goes for fathers and mothers. And children too may have some issues as well, and that may cause problems, such as are the problems as a result of something that's innate with the child, or is the problem as a result of abuse that they're suffering? How can you tell whether a child is telling the truth about abuse that they might be alleging? I'm going to try to cover 3 topics today. We don't have a lot of time, and this is, as you can tell, just an immense topic. First is the importance of assessing the situation and getting some help to do that. Second major topic is strategies, the strategies that you can do on your own, and some strategies that we can do as lawyers in the court system. So 3 things: the importance of assessing the situation, and then some strategies that you can work on as yourself, regardless of what happens outside the courts, and then what can the courts do. So first off, in terms of assessing the situation, we've got to figure out where you are. I talked about that trial 25 years ago, and that was a case where the dad had supervised contact. So he wasn't quite cut out of the children's lives, but he was certainly, there was pressure to push him that way. That's very different than a case I dealt with a few months ago, where my client is in jail for a life sentence, and the parenting order that was previously consented to by his previous counsel said no guardianship, no contact, no communication. Wife the mother can move wherever she wants with the children. She doesn't have to inform him of anything, and she doesn't need his consent for passports, et cetera, et cetera. So completely 100% cut out of the children's lives. My client made the very good point that the kids were older, and as they became older, they may very well want to have contact with their father, who did something very, very bad, as you can imagine, because he ended up in jail on a life sentence. And so we were in court dealing with some fallout of the family law matters, dealing with property and that sort of thing. And the judge agreed with me, and that the parenting order could be revised to allow the children to initiate contact with their father. Small change. He still couldn't initiate contact, but at least the courts, the jail system, would then allow the children to have contact with them if they initiated it. So even in the direst of situations, I think that there's always something that can be done. Obviously, the assessing the situation is important. Do you even know where the children are? Have they been kidnapped? Is this something that is a recent change, or is this something that has been a problem for a long time? Is the separation from your children a result of court orders, or just there's been a change and she's the spouse is just not letting, or the other parent is just not letting you have contact with them? Those are very different situations. If there are court orders, there needs to be an application to change those court orders, and that may be easy, and it may be difficult depending on how long it's been since those the courts have made the order. Another issue that is part of the assessment is, are there criminal convictions, or are there criminal charges? Is that a complicating factor in this situation? Are there restraining orders or emergency protection orders in place? Are there peace bonds? Those are what is the legal context outside the family law situation that might be having an impact on your ability to, or giving justification to the spouse to keep the children away from the parent. Um, so what can you do in the meantime? And part of it is um, what are the things that you can do and should do even when you aren't seeing the children? And part of that involves an assessment of what where you are personally. Um, are there things that you as a parent have done that may have contributed to this problem? And 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 by doing that, I'm not saying that you need to uh, get overwrought with guilt or with blaming yourself, or what's this, I thought it was all the other side's problem. The it's, after all, isn't it my spouse that's preventing me from seeing the children? And all that may be very well true, that the spouse is maybe behaving very, very badly. The reason why I'm saying take an assessment of what your role in it may be is because the courts are going to assume that everybody's contributed to the problem. And so it's important to start off with saying, okay, well, if there's a problem, what can I do to fix it? So, for example, um, you may have been representing yourself in court, and the other side just knows how to push your buttons, and you react very negatively and make a very poor impression in court, and you bring up lots of irrelevant things, and you are criticizing the other parent, and not dealing with um, the issues, or the clear issues that the other side has raised, and that sort of thing. And the judge starts making very bad orders against you, sometimes maybe even ordering you to pay costs of the other side, which of course is making you even more and more frustrated. That's part of the assessment. Is there something that you've been doing that may have been contributing to the problem? Another one is take a look at your communication style with your ex. Um, and this information is actually readily available through the Parenting After Separation course. So some of this is anybody going through a high conflict divorce or separation with children is typically pointed to two resources that are on the court's website: the Parenting After Separation course and a Parenting After Separation in High Conflict. And these courses really do help, and they give you some insight. So this isn't particularly new. What might be helpful, though, is, it's one thing to be sitting there being told, well, treat your communications with your ex as a business relationship. Stay focused on the issues, and don't insult them. You know, you know, don't use profanity and all that sort of thing. And so the idea is that's going to reduce the level of conflict. And you take the course, you go home, and then you get the nasty message from the ex, and your stomach is in knots, and you pick up your phone, you see the text message that you got, and you forget everything that you learned in the class, and you just instinctively did what you've always done, and just unloaded. And you may not realize that it's a problem. And sometimes it's and sometimes the problem is not so much that you are saying things in a bad way, but it maybe it's just you're not dealing with what the right approach. And the right approach might be to simply ignore the communication. The right approach might be to ignore some of it and deal with other parts of it. And that's where sometimes it can really help to get a third party to look at it and say, okay, how could I do this better? How could I communicate better? Um, Sometimes that might mean, and that might be time consuming and whatever. I had a client that was um, had months and months of text messages with his wife, and uh, she was out of the country visiting family during this time, and was really deciding to that she was going to separate. And so there was some ambivalence about where they were at. And she came back and filed criminal charges and made all sorts of allegations against my client. And one of the allegations was that he was being abusive in his communications with her. So I looked at dozens and dozens, if not hundreds, of text messages. There wasn't a single insult. There wasn't a single use of profanity. There was lots of asking questions and not getting any answers. And so that raises a really tough question. Okay, so why is it that this person is going saying all of this is abusive? Well, it may be that they've got the problem and it's not you. Okay, so how do you deal with that? And I think even in that situation, there are ways to deal with a situation where somebody is overreacting or reacting in a weird way to just normal communication. What's going on with them? What's going on? What might be causing this kind of reaction? Um, Now, I'm not going to start throwing around labels like the X has got, this personality disorder or that personality disorder. I don't have the competence for that, um, or the training or anything like that. But uh, there is a useful book that I've. It doesn't deal with family things in particular, but it deals with negotiating strategy. It's called Never Split the Difference: How to Negotiate if your life depends on it. That book is written by an FBI hostage negotiator. And so you can say, okay, well, hostage taking is kind of like a parenting situation where an ex is keeping the kids from you, like he or she is keeping the kids hostage. What's interesting about this book, Never Split the Difference, is how you communicate to the other side, to the person who's the hostage taker. You can't split the difference, obviously. What you take half the hostages, I take half the other half. That doesn't make any sense. Sometimes that works with children that maybe one child goes with one parent and the other goes with the other parent, but that's really, really family dependent. So splitting the difference on something like uh, you know, a parenting hostage taking situation doesn't make a whole lot of sense. So here you've got an FBI hostage negotiator saying there is a better way to communicate. And it really starts with trying to figure out where the other side's coming from. What are their fears? What are their what's their biggest concern? As a hostage taker, are they concerned with that if they step outside the door, they're going to get shot? Or are they concerned about having to go to jail? Or are they just concerned that they, they just want somebody to know that they care or something like that? I mean, who knows? And that's part of the reason why you actually want to listen to and figure out what's going on. And in doing that, you have to be aware where your own issues might be triggering your inability to figure out where the other side is coming from. So I think this is an important first step you can do. I had another case where my client just was very incredibly frustrated with the other side, with what his uh, the mother of his child was doing. Just to give you an example, the allegation was that my client has put his 4-year-old daughter in a cage, and and that was the abuse allegation that was being made against him. And he explained to me, yeah, the in a rabbit cage. That's what it was. He says, yeah, we have a backyard. We have a rabbit. I put this fence so that the rabbit can hop around without hopping away. And then I put my child inside this fenced off area. Well, that's really different than the this person is sticking a child in a cage. Anyways, he was very, very frustrated because it seemed like almost, he does something good with his child, and the ex uses this to keep the child from him. He wasn't seeing the child at all. Anything that would happen, he would get very, very frustrated. And that level of frustration made it difficult for him to make any kind of good decision, and he would frequently lose control, oftentimes in presence of the opposing counsel, and that just made it worse and worse. I said to him, well, why don't you take out a piece of paper and make a list of all of the good qualities that your ex has. He couldn't come up with a single good quality. And I think that it sounds like an odd exercise, but it's partly a helpful exercise, because if you can build on somebody's good qualities and the court sees that you are recognizing their good qualities, you are more likely than not to get somewhere. Now, this is one of those examples that one size doesn't fit all with this stuff. It might work in your situation, it might not. But trying to get some kind of understanding of where your ex is coming from is I think, very helpful. If there's things that you can do to improve your emotional regulation skills, and that's important, as you can see, somebody is losing their temper in court, that's clearly going to go badly for them, because the court is going to assume if they're losing their temper in court, if they're jumping up and interrupting the other side, or interrupting their own lawyer, or worse yet, interrupting the judge, that kind of thing is going to make it more likely than not that the court is going to rule against them in trying to get their application. If they want to see the kids, the court's going to keep saying no if that's the way they're reacting. So it's important to work on improving your emotional regulation skills, and that's something that it's no shame to go get some help on this. It took me a long time to figure this stuff out. That there was things that would trigger me, and people could push my buttons. It's much more difficult now. It's a learned skill. The other thing that's important to do is keep a record of everything that's going on. And this is important, that if you have records of communication, or records of Facebook posts that the other side has done, or bad things that the ex has done, it's important to preserve that evidence as much as possible. Making notes of things that they've done to interfere with your relationship with your child. It's important to gather as much of that evidence as possible. But you got to be careful when you go to use it. Don't just dump all of it. You need to make sure that you have somebody looking at it to say, okay, which are the critical issues? If somebody's standing in the middle of the street and shoots somebody, and the witnesses are focused on what the shooter was wearing and not on the fact that he shot somebody, that's not what the shooter was wearing is probably irrelevant. Might be relevant, probably not. Just an example that you got to figure out. There's a hierarchy of evidence. So, but you gather it all, and then you get some help sorting it out. Um, and then what you want to do is don't start publishing this stuff on the internet. And in fact, you should probably be very, very circumspect about what you are publishing on the internet, on social media. Just be careful, because the other side is probably paying attention, and you say anything nasty, and it can and will be used against you, not just in the court of law, but also in terms of keeping the kids alienated from you. As tempting as it is to say the truth out there on social media, just be really careful about it. And that goes, the other thing to say is, going back to the issue of, is somebody, if there is an issue with, if there's a no communication order, then don't violate it. That's really important. I said that in the previous podcast here. If there's an order saying you can't communicate with the ex, don't violate it. If it's so broad that you can't even communicate with your ex to a lawyer, then go get that order changed. That's not a difficult change to convince the court to do, usually, because they say, look, there's got to be some way of communicating. Okay. Now, when it comes to, in terms of legal strategies, the first thing, it depends on whether there's an existing court order or not, and so because if there is an existing court order, you can't keep running back to court unless there's a material change in circumstances that allows you to do that. And what constitutes a material change in circumstances? Well, you could say, well, the children are now older. Yeah, but are they enough older? There could be new evidence that you've uncovered that you didn't have before. You may have had some substance abuse issues that that have now dealt with. You may have had criminal convictions, and they've now been dealt with, and those may be regarded as a material change. One of the reasons why it's important to get legal advice is because if you've been representing yourself and an order is made, it may be much easier to appeal it than to try to change it down the road. But there's usually a very short window for filing an appeal. So if you don't like an order that's been made, and it's, you need to see a lawyer within days. Don't put it off for weeks and weeks. Typically, an appeal period for most things is 1 month. Some things it's shorter. So it's important to get legal advice as soon as possible on that, because an appeal, if it's a real clear error, like the judge just didn't understand the evidence that was in front of them, and that I've seen that in one of my recent cases, I think that an appeal would have been a much easier route than trying to go back and argue for a change later on. Now, the other thing that the court can do is order some professional assessments, and those professional assessments can either be in terms of evaluating what's going on. So getting a psychological assessment on one or both parents, doing a home assessment, a custody and access assessment. These assessments can be very, very expensive, and depending on the situation, they may be helpful, they may not be. The other kind of professional intervention that the courts can order is a therapeutic intervention. And that is where, okay, there's been a problem. The kids have been cut off from their parent. How do we fix this? because that's not a thing that's a long-term good idea to keep kids away from both of their parents. So how do we fix it? Um, and if the conditions are right, let's see what we can do. So that involves maybe some assessment of the parent. It may involve some supervised parenting time with a professional, where the professional is observing the interaction between the parent and the child and saying, okay, and then is able to report back to the court saying, yes, the interactions were fine. There should be no reason why this parent shouldn't get more access. Doesn't necessarily need to be done on a, supervised by a professional. Maybe it should be supervised in some other way. The goal in these situations where there's been a real serious cutting off of parenting time, and there's been some serious allegations of wrongdoing, and that's all gotten resolved, and now we want to get the situation fixed and get the child or children back with their parent. The courts are generally speaking going to go on a phased in approach where they're going to say, okay, well, let's start with a little bit and see how that goes. If it goes well, let's do a little bit more. If that goes well, then do a little bit more. And ultimately, using that approach, you may end up with getting to what the courts might view as normal for your situation. Or for people in similar situation, which might be every other weekend and that sort of thing, or it might be full 50-50 parenting with the other parent. All of that really depends on the situation. The courts really do want to avoid making a really drastic parenting change where, all of a sudden, the child hasn't seen their parent for a year and a half or 2 years, and all of a sudden they're dumped off with this person. Depending on the age of the child, the child might hardly know their parent, and all of a sudden they're dumped off with this complete stranger for overnight weekends and a month in the summers. That's not likely to happen if it's that kind of situation. That goes back to the importance of assessing what's going on in the first place. Where are we at? Because where we move forward to, it may be have to be in a phased in situation. But I also say sometimes, if the ex is not seeing your kids because the ex is a danger to the kids, then clearly in that situation you need to step in and do something. So I was representing a father that was seriously concerned that his wife was so dangerous with children. He actually had a tape recording of his wife banging a butcher knife on the counter while threatening to, or promising actually to cut the child's ear off and cut the child's tongue out while they're sleeping. And the child is in tears and going, mommy, I promise it won't happen again. And mom was just saying, no, it's too late. And we have a tape of this. So he was really concerned that if he just did the usual, well, I'm going to apply to for custody of my kids, that there was going to be some real harm happening. So we went into court. We got an order without notice. We went in there with police assistance and took the children and got them into my client's care. So that's why I say assessing that's a huge difference from, okay, my clients had some issues with alcohol and drug abuse. He's been in rehab. He's got a consistent record of clean drug cases. He's got a good relationship with the children. No, he doesn't need supervised time with his kids. And the courts are going to bend over backwards to make that happen. And he's going to get a much more regular time. So you got to know the situation. And in between those extremes, it's sometimes really, really tough to know what the best plan of action is. But trying to figure it out on your own is really tough because you're not objective. You're in too close. You can't see the forest for the trees, and that's going to hurt you when you go into court. Okay, so um, that's kind of a big picture look at the problem. Maybe at this point we can open it up to some questions. I've been kind of talking nonstop, and hopefully there's been some helpful comments in there. Maybe that's some sparked off some questions. Where are we at with the questions, Melanie?
Hey, Charles. You can hear me, right?
Yes, yeah, I can hear you.
Awesome. So we've got a few questions.
Okay.
So I will read the first one. It's a little bit situational. So the first question is, I have not seen my daughter in over 2 years. It started out with my ex suspending visitation because of COVID, and now has evolved to evolved that our daughter does not want to see me with no valid reasons given. No court orders or criminal records involved. Our daughter will be 16 in July. Is there anything the courts can do given her age?
Yeah, this is really tough because an older child, their views are going to be considered, but how do we know what the daughter's views are? And that's may be complicated, and that's a really tough situation. Um, uh, there are things that can be done. Um, uh, the it and you can go make a court application, and it really depends on what evidence you have that of wrongdoing by the ex in that situation, and really, if you can find the linchpin, the piece that's really going to be significant, that you can prove, and then you can leverage that to saying, look, yes, you say to the court, then, yes, I recognize that my daughter is 16. Maybe the daughter has special needs. Maybe the daughter is maybe that you've got evidence, and again, yeah, this can't be speculative. You've got to have some kind of evidence. You can say, like, there's a reason why she's been she's living in fear that if she sees me, something really, really bad is going to happen. Uh, Again, that may be it's I just don't know all the details, right? And that's really one of those things where you say you got to take a good hard look at the situation, and maybe it means um, uh, um, knowing how to communicate and finding a way to communicate to the daughter in a way that doesn't push the daughter away, or feel like she is being dragged into a dispute that's really with your ex. So that's where it can help to get a professional counselor involved to see what can be done if you've got any kind of open communication. And sometimes it may mean communicating even if you're not getting the response you want, right? Going back to those communications between spouses that sometimes can be problematic. If you're sending text messages to your daughter and you're just getting snarky answers in response, well, maybe take them to a child psychologist and say, can I be communicating in a way that's going to open up, let my daughter feel that she can, in fact, communicate with me and it'll be safe. Right? There's various things. I don't know if that helps or not. This is, by the way, really is a tough area of law. It's, I got to say, I don't want to say that there is success is guaranteed on this. I just can't as a lawyer. But I think that there's always things that you can do. And maybe, sometimes you just have to wait until the child is older and the ex just can't get involved. And that may be really hard. But that's, yeah. Okay, next question.
Sure. This one actually just kind of follows up to that question. So,
Okay.
is there an actual age at which a child can decide for themselves to not visit a parent?
The the rule of thumb that you'll hear often is 12 years. A 12-year-old gets to say where they want to live and who they want to have contact with. However, I have seen orders that ignore those wishes from an older child, and I've seen the child's wishes as young as 5 be taken into account. Whether that's right in the situation or wrong, it's I have my views on that. There's it really is unfair to some extent to put a child to that question, and that's one of the strategic decisions that you can make, I suppose, is, do we try to get a children's lawyer appointed so the children's lawyer can go and talk to their client and find out what they want? And they can do that whether the child is 16 or whether the child is 5. If the child can communicate, then they speak their wishes to the lawyer. That, but that raises there's some practical problems. How do you know whether the child is actually saying what they truly wish, or whether they're just siding with the parent who they think is going to win, or the parent that they last saw, or the parent who's coached them on what to say? Or why is it the child's decision in any situation, regardless of the age? Why are we putting a 12-year-old or a 13-year-old to the task of deciding between their parents? So this is a tough issue, and I'm not convinced that the courts always get it right, and the courts aren't necessarily consistent with this. As I said, courts consider the wishes of children, and when I say like the case I'm thinking of, I was actually representing mom, and I was keeping dad away from. I was maintaining the no contact. So I just want to say that there's I've worked on these files from both sides. As I said, I had a father that got sole custody of the children from a crazy ex, and I've also represented moms keeping children away from possibly dangerous fathers. So in this case, the child was allegedly saying that what was happening was that the judge was saying, I want to hear what this child is saying. I want to be hearing it straight from the child, not through mom. Well, the issue was, in my view, I don't think it was appropriate to be asking the child because of the child's age. Judge disagreed. Does that help? Are you there?
Helps if I take you off mute before I start talking.
Okay.
Well, here's another question. How can a mother harm her children by cutting the communication off from the father? Does the system consider the mental health issues of children and fathers? Many men commit suicide due to family issues and it screwed up their life. Does the system take responsibility for this?
Okay. So Unfortunately, the short answer is that the system, as the legal system, doesn't take responsibility for it, because the legal system is really trying to um, uh, resolve disputes, and in a way that uh, is effective, but they recognize that it's an imperfect system, and they uh, the courts recognize that they might get it wrong, but they are trying to get it right. Um, Now, is it in the best interest for the child to be cut off from their parent? I typically don't think so. I do child protection work where I represent parents whose children are being taken away from by the state, by the government, because I think that children are better off knowing their parents as they are, unless there's real danger. And I think that one of the problems that I see is that our concept of harm and danger has been so watered down that you it's almost like it doesn't take much to justify um, like a if one parent is using some profanity around the children, does that mean that the children shouldn't be around that parent? Uh, that's uh, I would say that shouldn't be enough. But unfortunately, the courts will sometimes hang their hat on that kind of behavior and say, well, that's harmful for the child to be around that kind of uh, parenting. So there was a few questions in there. How can a parent do that? Unfortunately, they do. And that's part of going back to that assessment. I mean, how do you know whether why is the spouse, why is the other parent doing this? Are they doing it because they have a legitimate fear? They have a legitimate concern with your behavior that you just don't see? Do they have a fear that is made up? Uh, are they triggering because of baggage in their own back, their own history, their own, are they projecting onto you issues that they have? Are they are they um, are they just being vindictive? You hurt me. You had an affair. I won't dig. I'm not saying that having an affair is not is okay, but sometimes the law doesn't care about those whether you have an affair or not. So you have an affair because, well, we don't get into the reasons why you have an affair, but you have an affair, and now you've got a spouse who's just being vindictive, and so she's not going to want to let you see the kids. Or maybe the parent who's cutting you off from the kids is the one who's had the affair, and she wants to recreate this happy life where she doesn't have to bother with shunting the kids back and forth, that somehow has interfered with her image of the perfect family of mom and a dad and the kids, and everybody's happy. What she doesn't want to be reminded of, oh yeah, there was a failed relationship in there. Or this is where the answer to these questions really helps determine what the answer is. One thing that I think can happen is the 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 parent who's keeping the kids is making false allegations because they're really afraid that if anybody looks really closely, that their parenting, they feel very insecure about their own parenting abilities, and they're afraid that if anybody looks at their own parenting abilities, the kids are going to be taken away from them. So one way to prevent that from happening is lash out at the other parent and say they're doing all sorts of stuff and cut the kids off. The bottom line is you got to figure out what's going on. um, I had and that requires some self-awareness and some awareness of what's going on, and maybe it involves getting the viewpoints of family members or friends who know what's going on. And this is say that's what makes this a really tough area. It just don't know what's going on. Okay, next question.
Okay. Next question is, in regards to when you made the comment about the hostage negotiator and figuring out what the other side wants, how does one deal with the common theme that the other side simply wants to destroy and hurt you for reasons of vindictiveness and retribution?
Well, this is that may or may not be what's going on, right? There's a conclusion as to what their motives are. Here's a funny thing about what humans do. We are more likely going to ascribe to the other person, and this is not just a parenting thing, this is just whatever. You have a dispute with somebody, you are more likely to assume that the person is doing something to you that's mean, has got an evil motive. Otherwise, they wouldn't do it, right? That's the way we get through life. We say, "Oh, that person is being mean to me. I don't like what they've done. They're being mean to me." I'm sorry. I'm just trying to say this is a really broad issue. And again, I'm not a professional, but what happens then if you do something to the other side that could be perceived as being mean to them? Well, I didn't mean to do it. So we tend to let ourselves off the hook. We say, we didn't have a mean intent or a bad intent. That was an accident, or, oh, I didn't realize, or whatever. And that's across the board. And so when you make you have to be very careful when you're saying, okay, well, this other person, this hostage taker, is just being vindictive. I don't know. Is that what's going on? And the key, if you go get that book and read it, the key is you got to start by listening and seeing it from their perspective, which is really, really hard when their perspective is filled with vitriolic accusations against you. That's why it really helps to have a lawyer involved who can actually take a look at that without an emotional reaction to it, because it's, the attacks aren't directed in most cases to the lawyer. Sometimes they are, but that's another story. In which case, just to say, just to give you an idea, when a lawyer on the other side of one of my cases starts getting angry and wound up and starts attacking me personally, I actually calm down, because I realize they must not have a very good case if they got to rely on that kind of behavior to get anywhere with me. So, that's why I say you have to evaluate the situation very carefully. I got funny stories about that too. But okay.
Okay. This is a kind of a situational one. Access is ordered to 3 children, but he is denying it. Judge is seized, but intends to withdraw and will not allow me to make an emergency or other application. I'm self-represented in quotation or in brackets. What can be done?
So read that to me. So let me understand this. So you've got an order that's giving you parenting time, and it's not being followed. Sorry, read the question again.
It says access is ordered to 3 children, but he is denying it.
Okay.
Judge is seized, but intends to withdraw and will not allow me to make an emergency or other application. What can be done?
Okay. All right. So this is a situation where you've probably dug yourself into a really deep hole. And I say that because there's some things that are going on there. So the last thing you said is that the judge is not willing to make any emergency application. That comes when too many applications have been made and the court and they've been unsuccessful. And that's where you've taken your approach has been you're so frustrated that you keep going into court and not getting anywhere and raising all sorts of irrelevant stuff and whatever. And the court says, okay, we're not going to let you bring any application unless you get leave first. And I don't even want to deal with this anymore. And it may be that this judge is, and I don't know, it may be that the judge is saying, look, I shouldn't be the one to decide this because clearly, there's some kind of situation going on here. The other thing that I want to say is it also depends on the court. That one of the issues that has arisen because of COVID is that you can't get into court in the Court of Queen's Bench without going first to family docket court. You can't just bring your emergency application. At least that's what it looks like from kind of on the surface. The courts do allow emergency applications, but you have to go through a special application process to get around that family docket court gate, shall we say. So I don't know whether the problem is whether there's been an order that you can't bring any further proceedings because you've been found to be a vexatious litigant or something like that, or whether it's a procedural thing and you may not just know what the procedures are. Now, if you are a vexatious litigant, if that's order has been made against you, it really, really helps to retain a lawyer. All of that time and effort and emotional energy that has been used up getting nowhere, digging this great big hole, is probably better spent earning some money and paying a lawyer to take a look at the problem. Because you may have a very good case and there may be some key points that the court needs to see, but you might be having trouble putting it together in a way that the courts will actually see it because they're overwhelmed. The court is overwhelmed by other stuff that you're raising that you feel is important, but the court doesn't agree. The court won't agree because for various reasons, that's the way lawyers think sometimes. So if you, in that case, that's where you need somebody to take a look at it and say, okay, this case, you don't have the evidence. This case, you do have the evidence, but it's too late. The court's not going to reopen it. You need something else. You need to get a legal opinion at the very least. And if at the end of that assessment of what the merits of your case are, yes, the lawyer says, yeah, we can get in there, but we're going to have to get around this vexatious litigant situation. Then what happens is the lawyer goes into court, makes the application for permission to bring the application. And in the course of bringing that application, the lawyer is going to say something like, my client acknowledges that he or she has filed a number of applications that have been quite frankly vexatious. He or she has now retained me and we've been assessing the situation. And as an officer of the court, it appears to me that there's an issue that requires litigation. That is an argument that's likely to be successful, but it requires letting the lawyer make it. And that means you got to let go and let the lawyer assess the case.
Okay. In regards to your example earlier about the rabbit cage, obviously any reasonable person can recognize the manipulative mischaracterization of a simple, fun interaction between a fun-loving father and his child. Why does the court not call out this sort of blatantly improper presentation of a common sort of play.
I'll tell you what happened in that case. That allegation was made in a court application made by the lawyer for the mom in that case had a habit of attaching exhibits to attaching affidavits, previous affidavits as exhibits to current affidavits, and attaching this and that. And he ended up with, I think by the time I was retained for that first application, there was something like 1,000 pages. The case was heard at the end of the day, around 4 o'clock, as I recall, by a judge who, this was a regional court outside of Toronto. I practiced, this was a long time ago. This was, I was doing this in a suburban community just outside of Toronto. And there were 3 judges, and the first judge saw 1,000 pages and said, I'm just going to play it safe here. I'm going to suspend access. Okay, there's enough. I'm not going to make a decision. I don't have time to make a decision. I don't have time to read this stuff. I've heard there's enough stuff, and obviously the rabbit cage thing wasn't the only allegation. Remember, my client's anger probably contributed to it, but probably so did the history of paranoid schizophrenia in the mom's family members. So anyways, there are a lot of moving parts. Anyways, the first judge suspends access, and then it goes back in front of judge number 2. Judge number 2 had developed a reputation, sadly, of finding any possible way to avoid making a decision. And this had come to the attention of the regional judge's manager, or whatever their official title is in Ontario. I can't remember now, so long ago. And the court clerks were directed that if judge number 2 had adjourned the matter, it had to stay in front of that judge, because the courts were saying, we have to get this judge to make a decision. And I got to tell you, after my client blew through $20,000 of legal fees, and I got absolutely nowhere with judge number 2. And I still remember to this day going on Christmas vacation with this knot in my stomach. How could I blow through $20,000 worth of my client's legal fees and get zero result? And my client said to me, I'm sorry, I've just run out of money. So he goes back to judge number 3. Judge number 3, the first 2 judges were male. I don't think their gender has anything to do with it. Judge number 3 had been involved with the case before, so she was familiar with it. She had made some initial order or whatever. The client goes in without notice into court because he doesn't know what else to do. And he says to judge number 3, and the mom's lawyer is there because he's there every day before these 3 judges. And he describes, without any kind of affidavit or anything, as I understand it, and he says what's going on, and judge number 3 gives him access. Whereupon mom appeals, and the whole thing starts over and over again. So I didn't know the question. I can't remember what the question was. Oh, the rabbit cage situation. Why wouldn't the court see through it? Well, that's why, because the strategy in that case with this particular lawyer was pile on, so nobody can actually get to the truth of the matter. And I got to say that the courts have kind of wisened up to that strategy, and you now are not allowed to attach affidavits as exhibits. You can't. There's page limits in family law matters. You can't. Your main affidavit can't be, more than 5 pages. In that situation, one day, on the morning of court, it's 7:30, 8 o'clock in the morning, we got court that day, and I received a 62-page affidavit on my fax machine
Okay, so those kinds of strategies are not allowed anymore by the courts. That doesn't mean that people don't do them, but there are ways of dealing with it, because you can actually point out to the judge that, it's actually, the judge shouldn't be having regard to any of it, given the nature of how this thing was generated. Sort of thing.
Okay. Next question. Have you dealt with mobility situations? My ex took the kids, ages 6 and 5, been there since last September. I've been documenting unwarranted, restrictive gatekeeping and parental alienation. Do the courts consider alienating behaviors?
So one of the big hurdles that you have to face is, it sounds like the ex has taken the kids, and if it's been 6 months, you're in real dangerous territory, because they're winning by default. And they're winning by default because a new life has been established. And remember that the court is not really deciding between the parents, who's the better parent. Sometimes they have to, but they're trying to do what's in the best interest of the children. And if the children have become settled in a new life, you've got to have some really good grounds to uproot them. And they've got to be good grounds from a lawyer's perspective, not, yeah, I saw that guy shoot him, but did you see the shoes he was wearing? Like, who buys pink running shoes? So you got to be really careful about the hierarchy of evidence that you have. Like, the hierarchy is what I'm calling it. You got to be able to figure out what's important, what's not important, what's a court going to care about, because that's really what's important. What's a court going to care about? And you've got to get rid of the other stuff, or you got to decide what stuff is here's a really good example of a mistake that people often make. Is they'll make a statement in an affidavit, and even though it's not likely to be disputed by the other side, they'll attach an exhibit to prove the statement they made. And you go, well, what's wrong with that? They made a statement, they've added proof. But the missing piece there is the other side wasn't likely to dispute it. And what the effect of doing that is saying, I made this statement, but I'm afraid you're not going to believe me. So I'm going to have to make it. I'm going to have to prove to you that this little statement that really has no big significance in the grand scheme of things, you need to believe me on this little thing. So I'm going to prove it by attaching an exhibit. Much better strategy is to make the statement and expect that the judge is going to treat your word as being truthful, because after all, an affidavit is a statement that you've sworn to be telling the truth. So treat it like you are telling the truth. If the other side contests that issue or disputes it and says that you're lying, that's when you pull out your proof. But if they don't dispute it, now you haven't wasted the time and the size of the court file with a document that was proving something that really didn't need to be proved, because your word was sufficient. So and again, that sounds like a really, how are you supposed to know that? Well, that's where getting an assessment from a lawyer really helps. And unfortunately, not all lawyers know that, or they know that if you can figure out a way to put enough stuff in front of the judge, to like that lawyer with the 62-page affidavit at 7:30 in the morning, that's a strategy. It's not a strategy that I think is a good strategy, because and there's ways of dealing with it. I don't want to. There's all sorts of rules of civil procedure that can be brought to play, but you got to know what they are and know how to use them and when to use them and when the best time to use them is, and all of that is a tricky exercise. Okay.
Okay. Um, are there options of what court you go to?
So there are options. They um, in some cases, and there aren't options in other cases. The problem arises, and you say, well, why are there two courts dealing with family law matters? And the reason is because divorce is a federal matter, but marriage and property is a provincial matter. So that's a division of powers matter that was decided back in 1867 or whatever, when they're leading up to Confederation. How are we going to divvy up who gets what powers? And so the federal government got divorce, provincial governments got marriage, and well, then you say, well, how does that make any sense? Well, it made sense given the there's a history behind it, and it has to do with church and state and the state of religion and English Canada and French Canada and all of that. There's the interesting history, but that's obviously way beyond what we need to cover here. But because of that division, so in the Divorce Act, the Divorce Act includes dealing with children and child support and spousal support, but it can't deal with property. Well, why can't it deal with property? Well, just like when they divvied up, marriage and divorce and gave marriage to the provinces, they said provinces are responsible for property and civil rights. So property is a provincial matter. The federal court, the Federal Divorce Act, has no constitutional authority. The federal government doesn't have any constitutional authority to make any rules or anything about property. Okay, so if you are legally married, then that means that you can go into the Court of Queen's Bench, which I think there are some advantages to, and there's the advantages and disadvantages of each court, and I don't want to get into that at this point. But generally speaking, no, I'm not going to say anything. But in the provincial, you can still go into provincial court even if you're legally married, because maybe you don't want to get divorced. Maybe you just want to get child support, or maybe you just want to get a parenting order stuff sorted out, and you just want to leave the divorce because maybe for religious reasons you don't want a divorce, or maybe you think maybe there's a hope that after things settle out, maybe you guys will get back together and whatever. So you can go into provincial court. Provincial court tends to be a little simpler in terms of its procedures. It's a little more accessible to people who are self-represented. So there's an appeal to going into provincial court. But if you've got if you want a divorce, well, then you have to be in the Court of Queen's Bench. Now, the interesting issue is what happens if you have a property division issue and children, but you're not legally married. And that's where there's a bizarre situation that's arisen because of COVID. Because getting into court on an application under the Family Law Act dealing with children has to go through the family docket process. You can't even file an application to get a parenting order, regardless of which side you're on, whether it's to keep the kids or get access to the kids or whatever. You can't even file the application without going through family docket court. But you can file a statement of claim for division of family property, even though the parties weren't married. That's because the provincial government has extended property division to non-married spouses. So now you've got a situation where you have and I've got a case going on right now where we have a statement of claim for division of family property in the Court of Queen's Bench, and there is a dispute between the lawyers as to which court should deal with the parenting matters. And there's a procedural hiccup because of the COVID rules that set up this family docket court that make it that are an impediment to actually filing the application, and at which point it's already in play, and the because you can't start it with a statement of claim, you have to start it by an application, which has a fixed court date. In provincial court, there's no claim process that doesn't have a fixed date, so you get into court quicker, so to speak, possibly in provincial court. So you might end up in two courts. So that's really, hopefully that didn't get too complicated. Sorry.
Okay,
It's a tough issue, and yeah, and it can be confusing if you're not a lawyer. It's confusing if you are a lawyer.
for sure. We only have time for one or two more questions. Unfortunately, we're not able to get through them all. Does the court give due and proper consideration to the fact that a parent has enormous financial incentives to get and maintain primary parenting?
Yeah, that goes to, you might see it as a motive. I actually tried to raise that argument because my client was convinced that was going on, and the court went out of its way to say that that wasn't what was going on, even though they had no evidence. But that's neither here nor there. The important thing when it comes to financial matters and parenting time or custody and access is those two issues are not supposed to be connected. So you have to sort out where the kids are going to be living, who's going to be caring for the kids, whether it's going to be shared custody or whether it's going to be primarily with one parent or the other. And once you've determined that decision in the best interests of the kids, then the support follows from that. Now, if somebody's not paying support, that doesn't allow you to withhold the children from the non-paying party, right? So that similarly, you can't use the money to say, well, I'm not going to pay you support if you're not letting me see the kids. Though the kids are not for sale in from either perspective. So yes, there can be a huge financial motivation, but the courts are gonna I raised that in court because it was really the only last possible straw to grasp. Okay. And even that one didn't work. So you don't want to make that accusation unless you've got lots more stuff on your side.
Okay. Next question. Why are there such strong enforcements for support and no matching enforcements for parenting time?
Because it's easy. Because, showing up with the police to enforce a court order for children is something that the courts are really reluctant to do. Because think about it, you want the children to grow up viewing police as being there to protect them, to uphold law and order. You don't want children to be seeing the police as somebody that comes and rips them from their arms of the parent that they really love to be with. So the courts do make police enforcement clauses, but they're hoping like hell that they never get exercised. And that's where you have a problem. Now, so then the question is, well, what do you do about it, right?
And that's where the court can make financial orders against the spouse who's violating orders. But even there, the court's got a problem, because if they make a punitive financial order against a parent who's withholding the children, then isn't the real risk that then that parent won't have sufficient resources to feed the children, and so it's harming the children, which you're trying to make an order that's not going to harm children. You're trying to make an order that's in the best interest of the children. Do you see why when I started this is a very, very difficult area of law, because these are, and I'm it's really hard to find the right path. And that's why sometimes what you'll see is the judge going, look, there's no merit to this at all. I'm switching custody, because then the if you need the police to go in, you do the switch, and that impact of the police is minimal. It's once and done, and now the kids can get on with their life, which is what happened in that case where we went in with the police assistance, got the kids out of that situation. The kids stopped having nightmares. They stopped having to sleep with the lights on. They started doing better in school, all sorts of things, right? So now, so and I could go on. It's a really tough thing. How do you enforce a parenting order? And you know, the courts recognize that sometimes a parent can be in the wrong, and the delay really hurts the children. And that's why it's so important to get your ducks in a row and get the evidence lined up that you need, and get it in front of a judge, and get the right decision made in the first place. If you've got evidence that the withholding parent is a real danger, then that obviously helps to get a higher level enforcement. And as to child support being easy, yeah, it's because it's, doesn't take much to file something and get your license taken or your passport taken.
Mm-hmm. Great. Okay. Well, unfortunately, we didn't get through to all the questions, so I apologize for that. But we're going to wrap it up, given we went over by half an hour, knowing that there was a lot of questions.
Okay.
Yes.
Can you, Melanie? Can you copy all the questions, and then we, if there's questions that we didn't get to, maybe that can be a topic of a future webinar.
Yep, I have all the questions.
I think that's a great idea.
Yep, I have them all.
Great idea, Charles.
Very good. Good. Yeah. Sometimes I have good ideas in court too.
Well, that's good. So just to make a couple of closing remarks, on behalf of the Canadian Centre for Men and Families, Alberta, I want to thank you, Charles and Melanie, for spending your valuable time to offer this engaging and informative seminar, and for taking the time also to answer so many questions. And I want to remind our participants to visit ccmfalberta.ca and learn more about our programs. We offer domestic abuse recovery for men, counseling, peer support, mindfulness meditation, and of course, great legal educational offerings like this one. Please check your email after the session for a post-session survey, just a few questions long. We would love to hear from you about what you thought of this webinar and what other topics you would like to see us cover in the future. And lastly, one of our participants sent me a message and asked me to say it out loud to the group. And I think it's a really good message for the population we serve. So I said yes. Some men choose to die by suicide, but most men somehow find the strength to carry on, get the support they need, or struggle on and reconnect with their kids eventually within a few years or within 10 or 12 years. The situation is never that hopeless, even in the extreme. And self-care is the most important thing for parents, male or female, who experience parental alienation.
Yeah, that's
Thank you,
yeah.
That's it. Thank you, Vanessa, for reading that out. Yeah, I 100%.
Yeah,
agree.
thanks to the gentleman who sent it in. And please join us next month for another important topic.